Okay, we're going to go ahead and get started. Good afternoon, everyone, and welcome to today's webinar. Again, my name is Michelle Peterson, and I'm the training manager for the Empire Justice Center. First, I do need to note that today's webinar is made possible by the New York State Property General Home Ownership Protection Program. Before we get started, I wanted to take talk quickly about how you can interact with us today. Everyone has entered the webinar in listen-only mode. If you have a question on the material being presented during the webinar, enter your question using the questions located on your control panel. Questions will be addressed both during and at the end of today's presentation. Note that this webinar will also be 90 minutes, ending at 1:30. We did send out a notification on November 5th that we felt we needed to extend the webinar due to the materials being presented. Also, within the last hour, you should have received an email from me that included copies of today's PowerPoint presentation, a PDF of sample pleadings, and the attorney affirmation form for attorneys requesting CLE credit. Today, we're going to be providing 1.5 CLE credits in the professional practice category. So to receive your certificate, note the verification code on your attorney affirmation form when it's announced and send your complete certificate to my attention. We'll also put the code, the CLE code, in the chat box, which is also located on your control panel. For non-attorney seeking a certificate of attendance, we can also provide that. So if you'd like that, you can email me directly requesting a certificate of attendance. And finally, at the end of the webinar, you're going to be asked to complete a webinar evaluation. So please take a moment to complete that evaluation. With the housekeeping out of the way, I'm going to turn it over to our webinar moderator, Kevin Purcell.
Thanks, Michelle. Hello, everyone. We have a lot of folks on the call today, which is great. And looking forward to this presentation. We've got two presenters today. First up will be Joseph Rebella. Joseph is a staff attorney at MFY Legal Services. He attended Harvard Law and then was an AmeriCorps Legal Fellow before joining MFY, where he started in 2012 and has done several trainings, I know, around the state and has a wealth of knowledge. So we're very excited to have Joseph with us. After Joseph, we're going to hear from Jay Inwald. For those, if there's anybody that doesn't know Jay out there, he's the Director of Foreclosure Prevention at Legal Services NYC. He came there in 2009 after spending about 25 years in private practice and has become one of the statewide experts on foreclosure procedural issues and in HAMP litigation on a nationwide basis, really. So we're very excited to have both of them here. As Michelle said, if you have questions along the way, please put them into the question box. I will try to jump in and make sure they get answered in a timely basis. So that everyone on the call is aware, at some point I am going to be stepping out as moderator, and Becky Keiko will be stepping in, so you may hear her voice towards the end of the call. I know there's been a couple comments already regarding audio being a little bit murky. If that continues when Joseph and or Jacob are speaking, please put it into your comment, into the question section or the chat section, and we'll see if we can get something taken care of. I think we've got that issue addressed. So without further ado, I'm going to turn it over to Joseph, and thank you all.
Okay, great. Thank you for the introduction. So how Jay and I have broken this up is I'm going to be presenting first on HAMP litigation sort of nationwide, and then Jay is going to really focus in on the New York context, which might be a little more relevant on a day-to-day basis. So as we said, I'm happy to take questions as we go on, with the proviso that if the question is, well, that's very well and good for the other 49 states, what about in New York? I'm going to ask that you hold that and let Jay's presentation address that. So great. Thank you for joining us. I'm Joseph Rebella. I'm a staff attorney at MFY Legal Services. And so let's just start with a legal description of HAMP, sort of what it is, what its basis is. So in 2008, Congress passes the EESA, which gives the Department of the Treasury the authority to implement a plan to maximize assistance for homeowners and minimize foreclosures. In February 2009, pursuant to this act, the Treasury announces the creation of HAMP, And HAMP is created through a series of servicer participation agreements that the servicers who participate in HAMP sign with the Treasury. The SPA incorporates, by reference, all program guidance, including the handbook and the supplemental directives. So, you know, first of all, I'm going to just point out and get it out of the way that this is a crazy way to make a public policy, and that all the work that we do trying to enforce HAMP, getting servicers to comply with HAMP, is because it was such a bad idea to make HAMP function in this manner. And that there's really a division between you know, these private contracts that the servicer signs with the Treasury and any incentive that anybody has to enforce those contracts. I'm also going to note that this legal history is the legal history of HAMP that gets described in pretty much every HAMP enforcement case that we're going to talk about. This is really just the story for the non-GSE HAMP, the handbook HAMP. But for the government-sponsored entities, Fannie Mae and Freddie Mac, basically, as you'll see, the same analysis applies. You can just replace servicer participation agreement with the contract that the servicer signs with Fannie Mae or Freddie Mac. If you're interested in FHA HAMP, that's in a different footing legally because those rules are sort of incorporated by reference into the mortgage itself, and we're not really going to be speaking about those FHA issues. So HAMP litigation has really followed in sort of 3 generations. Basically, HAMP litigation starts up when homeowners and their advocates notice that servicers are just not following the HAMP rules, and that there is really no way to get the servicers to step in and do what they're supposed to. And so there have been these, you know, I call them sort of generations of HAMP litigation. Of course, that's a simplification. There's a lot of overlap between the 3 of them, but I've broken it down by sort of claims under a private right of action, attempts to enforce the servicer participation agreement as a third-party beneficiary, and then what is, I think, currently going on the most, which is the enforcement of unconverted trial period plans, or TPPs. So we're going to go through each of those generations of litigation, and then we're also going to talk about a series of ancillary claims that may be pled falling under one of these 3 sort of general theories of liability. So the first off, and now this is what not to plead, and that's the private right of action. So in the very beginning of the HAMP program, homeowners just brought suits seeking to directly enforce HAMP. And some of these were brought against the servicer, saying, servicer, you know, I have a right to a loan modification, you need to follow HAMP, while others were brought against the Department of the Treasury or Geithner personally, and they basically sought to have the Treasury enforce the HAMP rules, since that enforcement power was given to the Treasury through those contracts. And they have a very intuitive reasoning, which is that the government told the servicers to do something. The servicers didn't do that thing, so there's got to be a lawsuit. Of course, possibly because it's so simple and intuitive, none of these cases get past a motion to dismiss. There's simply no private right of action in the EESA, and every motion to dismiss that you will face, no matter what your theory of relief or your cause of action is, the servicer's attorney will include the phrase, there is no private right of action under HAMP. And even things that are very clearly not causes of action even will get sort of that citation, and they'll be accused of simply being a runaround for the basic legal fact that there's no private right of action under HAMP. So as a result, you as the attorney have to be prepared to include language in your briefing explaining that your suit does not actually attempt to bring a cause of action based on a private right of action under HAMP. And you have to have sort of a theory as to how, and an explanation as to how what you're doing is very different than what those other cases did. So I've got a citation to a prominent case so that you can see, the basic, reasoning or lack of reasoning brought in these cases. Interestingly enough, I don't know if you've seen on the HAMP enforcement listserv, there is a professor at, I believe it's University of Indiana School of Law, who is writing an article on how there really should, all of the HAMP rulemaking should be subject to the APA, and, things that might suggest that there's room for private enforcement. But I think realistically, as far as what you'll see in court, is that they'll never be able to get over that mountain of cases that have accrued saying that there's no private right of action under HAMP. And if you did try to plead something like that, I would presume that you would just get, the brief that you would get back would be a single sentence that says there's no private right of action under HAMP, and then there'd be a string cite for whatever the court rules allow the opposition brief to be, just that many pages of cases long. So then after that, some more sophisticated homeowners attorneys brought suit under the theory that borrowers are third-party beneficiaries under the servicer participation agreements between the servicers and the Department of Treasury. And these suits point out that the aim of the servicer participation agreements is to encourage modification and preserve homeownership. And basically, there's no legitimate reason for HAMP to exist if its goal is not to benefit homeowners. So these really are contracts that identify third parties to the contracts and express an aim of benefiting those third parties. And there are some early successes. I've put out a great case, Marquez versus Wells Fargo, which was a 2010 California case. And it's very detailed and well-reasoned with a close reading of the SPA as to why homeowners really were third-party beneficiaries. But this theory is really eliminated when the U.S. Supreme Court decides Astra versus the County of Santa Clara. Astra was not a HAMP-related suit. It was actually a suit related to Medicaid. Under Medicaid, drug companies who participate have to agree to provide discounted drugs to public hospitals and community health centers. And so the city of Santa Clara was not being sold drugs at this discounted price, so they brought a suit. And the U.S. Supreme Court, and then so the Ninth Circuit found in favor of the county, and then the Marquez case based its opinion very heavily on this Ninth Circuit decision. But then the Supreme Court held that when the government is a party to the contract must not only show evidence to benefit a third party, but it actually has to express a desire that the third party has a right to enforce the contract, which is a much higher standard. I think the idea being that since it's the government as an actor, the government does have the ability to create a private right of action, and where it has chosen not to, the court shouldn't sort of willy-nilly read this into government contracts. And in fact, in Astra, the federal government issued an amicus brief basically saying, please don't let these, community hospitals enforce this as a third party. This is really supposed to be just the U.S. federal government enforcing these contracts. So that really killed the idea that homeowners could be third-party beneficiaries under HAMP. And it's kind of interesting in that if the Department of Treasury ever did decide that homeowners should be able to enforce HAMP, it could actually just unilaterally issue that in a supplemental directive, which would be incorporated by reference into the SPA. But they have declined to do that and have, basically the U.S. Supreme Court was defending the government's right to create public policy that was enforced in these horrible and tortured ways, which the U.S. government, really wanted to continue to happen. So that's where we are. After ASTRA, there have been several cases finding that borrowers are third-party beneficiaries to the SPAs, but these have all been state court cases that have applied the wrong law. I think there's 2 Massachusetts ones and maybe one in Georgia or Tennessee. But under the Erie Doctrine, which is everybody's favorite doctrine, contracts to which the federal government is a party are governed by federal common law. So these state courts ignored ASTRA, looked to their own state third-party beneficiary rules, and they really shouldn't have, they shouldn't have tried to avoid ASTRA. Okay, so now there has been success in pleading trial plan breaches. So most HAMP enforcement claims now generally tend to, as far as cause of action, tend to arise from trial plans that were not converted to permanent modifications. This is, of course, much narrower than if there had been a private right of action or if homeowners were third-party beneficiaries, because much of the trouble under HAMP is just getting to that trial plan, not necessarily having it enforced, although, of course, that does come up as well. And just looking at a trial plan and knowing how it works, you might think that these trial plans are clearly contracts. I make these payments, the bank modifies my loan, but there are some definite legal barriers to enforcing them. I'm going to talk about 4, which tend to be the 4 big ones. Lack of mutual assent, lack of clear and definite terms, the statute of frauds, and lack of consideration. Right now there's a circuit split as to whether or not TPPs are binding contracts. So we'll go through each of these legal barriers, discuss how the different circuits have handled them. And then one thing to note is, unlike the other 2 generations, really the TPP is going to be governed by a state law. So it's going to vary a bit because the TPP is governed by the state in which it's issued generally. But most of the issues that we're talking about are pretty much that, classic 1L contract foreign law that's going to be fairly uniform. So there shouldn't be too much variation. Okay, so first let's talk about mutual assent. So this is also, the sign and return issue. And the issue is that paragraph 2G of the standard TPP form states that the mortgage is not modified unless and until the servicer provides the borrower with a countersigned copy. And so the servicer's argument is essentially, in this one is, we never send a countersigned copy. Us sending a countersigned copy was a condition precedent to modification of the loan, so we don't need to perform because this countersigned copy never materialized, and this condition precedent was not met. However, on the borrower side, there are some other portions of the TPP, mainly in paragraph 3, that state that the servicer will send a countersigned copy upon the borrower's performance under the TPP. So the other side of the argument is just that paragraph 2G deals only with timing of the effectiveness of the modification and does not impact the duty of the servicer to, in fact, provide a modification eventually. And it certainly doesn't leave the modification to the servicer's unfettered discretion. Another common issue that comes up in the pleading is a lack of clear and definite terms. And the argument is that the TPP, its promise is so vague that it's insufficient to constitute an offer. And really there's a lot of terms missing in the TPP. The TPP is really just a payment. And the TPP doesn't even say, how much is going to escrow versus how much is going to principal and interest. It certainly doesn't provide all the terms of an actual modification. And even that payment, there's generally a note that it's subject to alteration upon recalculation. And if we have a TPP that's issued before June 2010, then the TPP is also subject to the borrower actually verifying their income. So in those cases, you could get a TPP either completely orally or based on oral information where, the borrower would say, I make $4,000 a month. They'd say, okay, great, you qualify, make your payments, and then, but while you're making your payments, send us your pay stubs so we can verify your income. So, they're trying to cast this as very provisional. There's still a lot up in the air. In response, the other argument is that the TPPs clearly require some sort of modification, which doesn't happen when the TPP is not converted. And then, sort of furthermore, the terms are implied because they're created through the HAMP waterfall, to which one response that I've had in briefing is that the HAMP waterfall does not specify the amount of principal forgiveness or forbearance because the servicer can, at their discretion, forgive principal that the waterfall says to forbear. But when the servicer runs the NPV test, they have to actually send to Treasury the actual terms of the modification that they're assuming when they issue the TPP. So really, at the time the TPP being issued, all the terms are set. At least the servicer knows them. And when you are dealing with those TPPs issued before June 2010, you really need to allege that the borrower did actually verify their reported income information exactly. So you need to say, you need to allege as a fact the borrower submitted pay stubs that showed that they made $4,000 a month, for example. Okay. So the next common issue is the statute of frauds. So you'll notice that so far this presentation has managed to cover both the Erie Doctrine and the statute of frauds. So this is just a great law school flashback. I tried really hard to get the rule against perpetuities into this, but I just couldn't. So maybe Jay had some luck with that, and he'll get to that in the second half. But otherwise, I think you'll have to just be satisfied with Erie and the statute of frauds. Now, because a mortgage is an interest in real property, it's covered by the statute of frauds. Modifications of contracts covered by the statute of frauds are also covered by the statute of frauds. So this means that a loan modification, a mortgage modification, is definitely going to be covered by the statute of frauds. And TPPs generally do not satisfy the statute of frauds requirements because either, well, right now, TPPs that are issued today are not signed by either party. There's just no signature. In the past, when the TPPs had signature lines, servicers just, as a matter of course, never signed and returned them. Very rare that during the trial plan, the borrower would receive back the signed copy from the servicer. And then before June 2010, TPPs could be completely oral. So what this means is that the homeowner's attorney is going to have to deal with the statute of frauds. So one argument that is generally made is that the statute of frauds applies to modifications of mortgages, but the TPP does not modify the mortgage. It's merely a promise to modify the mortgage. So the statute of frauds does not apply to the TPP. That's a little bit of sophistry there, and I think if that's all that you had, it would be a tough argument. So we're generally going to have to look for an exception to the statute of frauds. And the exceptions tend to be a little more state-specific than the general application of the statute of frauds. But some common exceptions that apply are, I think first and foremost, complete performance of the agreement, which basically states that the borrower completely performed with everything in the agreement, paid all 3 payments, sent in all their information, etc. And then another exception that applies is some sort of, estoppel or reliance, that the borrower has taken these steps and has relied on this this TPP by, making the payments, sending in their information, etc. So the last argument that I'm going to talk about here is lack of consideration. So of course, contracts must be supported by consideration. Payment of a debt that's already owed is generally not consideration. You need something new. Since the TPP is generally framed as trial payments in exchange for a permanent modification, the servicer will usually argue that the TPP is unenforceable because the only consideration are these payments on a mortgage that's already owed, and therefore the TPP lacks consideration. The standard of this is generally that the performance required is different in character in some way than the performance under the original note and mortgage. And really this is just, you should always be able to brief this because borrowers who fulfill their TPP agree to a ton of other requirements. They're making affirmations under the penalty of perjury. They're providing any documents that are needed. They're willing to attend credit counseling at their servicer's demand. They're allowing the servicer to release their personal information to the Treasury and to the servicer's contractors, which is, basically a waiver of their Graham-Leach-Bailey Act rights. And none of these are requirements under the original loan documents, so there should always be consideration. And, the standard is really you just need a quantum. Very little required. So let's talk about the circuit splits, and let's start with the good circuits. So the first federal appellate case was Wygod in the 7th Circuit. It was a great case. It had an excellent discussion of the contractual elements and found that TPPs were enforceable. Wygod did not address the statute of frauds because I think Wygod, the borrower, actually did receive a countersigned TPP in this case. And it did have a great discussion of the difference between attempting to enforce HAMP directly and suing under the TPP as a contract. So there's a lot of great language in there for when you need to explain that you're not pursuing a private right of action under HAMP. Next case to come down was Corvello Lucia versus Wells Fargo in the 9th Circuit. So it largely followed the reasoning of Wygod, and it did address the statute of frauds, and it found that the full performance exceptions to the statute of frauds applied. Also, this is a case that was my case that I briefed before I came to New York. So this is the best case, some really good briefing in that case. Then another decision that came out around the same time was Young versus Wells Fargo. You'll see Wells Fargo had a rough year there. Really got beat up on these decisions. But it held that the TPP is a contract that requires the servicer to provide a permanent modification consistent with HAMP. My favorite quote from it, Wells Fargo brought up this countersigned copy issue and the paragraph 2G issue, and the court described those as not implausible as a matter of language, which was just a great discussion of a great characterization of the amount of sort of linguistic gymnastics that Wells Fargo was engaging in to basically claim that it could do whatever it wanted. And, it had a duty to issue the permanent modification, but not if it didn't feel like it. And it noted that HAMP rules may be relevant as extrinsic evidence to interpret ambiguities in the TPP, which is also great since there is a lot missing from the TPP, and you do need really the waterfall and some other elements to fill in what's expected of the servicer if there's a TPP breach. Now, bad circuits. Basically, the Fifth and Sixth Circuits, did buy that construction that was not implausible as a matter of language. In the Fifth Circuit, it was clearly on the grounds of, well, they only promised to do this if the borrower was given a signed copy. In the Sixth Circuit, they really, I think, kind of muddied the waters and didn't differentiate between whether they were dismissing the case because of a lack of mutual assent or whether they were dismissing the case because without a countersigned copy, the statute of frauds barred the claim. So I think you could read it as either not being clear or as the court saying, well, either one of these are good enough, so pick which one you want to apply. Now, there are also ancillary claims that generally come with TPP breach and that you might want to include because, a common breach of contract action has some deficiencies in terms of, fee shifting, damages, and so you might want to plead a few other things that will generally be intertwined with the contract action. Now, in some courts, the breach of the covenant of good faith and fair dealing is brought as a separate action. Most jurisdictions understand that covenant as just an implied term in the contract. I think it really should be used to understand the sign and return requirement, namely to say, yes, the loan's not modified until the servicer returns a countersigned copy, but the covenant requires that there be a good faith and fair dealing and fair reason for them not to provide a countersigned copy if they don't provide a countersigned copy. But that's, I think, all we'll talk about as far as the breach of good faith and fair dealing. Some other claims that I think merit some further discussion are promissory estoppel, negligence, the FDCPA, the state UDAP, and ECOA. So promissory estoppel applies when the borrower exercises reasonable and foreseeance reliance on an unambiguous promise to perform. Promissory estoppel does not require contract formalities or consideration. So in some states, the statute of frauds does apply to promissory estoppel. I think in most states it does not. That may or may not be an issue. Servicers basically use the same contract arguments to say that there was not an unambiguous promise to modify the loan, to which we're talking about the same counter arguments. The problem with promissory estoppel is really damages. Generally, under promissory estoppel, damages are reliance damages. And since TPP payments are applied to a pre-existing debt under the terms of that debt, the court might even find that the TPP payments weren't reliance to the borrower's detriment since they were credited to a debt. So this probably isn't going to be a satisfying victory if all you have is promissory estoppel. You know, at best, I think you're getting the TPP payments, but, you know, like I say, you might bring an affirmative lawsuit, win at trial, and you recover the cost of faxing the documents, which I don't think anybody would be happy with. Now, negligence is another interesting claim. It tends to depend on whether, under state law, the servicer owes a duty outside the original note and mortgage to process the borrower's application for HAMP and to do it well, you know, with reasonable cause or due cause. So if the servicer's only duties are those under the note and mortgage, then the economic loss doctrine will prevent recovery under the theory of negligence. The economic loss doctrine essentially prevents plaintiffs from bringing contractual duties under negligence when there is only economic damages, the idea being that there should be sufficient remedy under contract. The benefit of bringing a negligence cause of action is that it doesn't limit itself to cases where a TPP has been offered. So it may be helpful for an especially bad denial, since the act that leads to the duty is generally going to be the processing of the application, essentially saying that the servicer undertook a duty by attempting to process the application. Some cases have found that there is a duty, but even in the cases that have been positively decided at the pleading stages, courts have been pretty openly skeptical. I've got here a cite to another case that was one of my cases, and it's expressed in the opinion, you know, California has a 6-factor test to determine whether or not there's a negligence duty. And it was expressed in the opinion and really came across in person that while at the pleading stage, you know, the court was willing to buy that there was putatively a duty, the court really thought that once some evidence got submitted, that it would likely find that there wasn't a duty in this case. And so that I think there is a lot of skepticism to bringing a negligence action. A great action to bring, if you can, is the FDCPA, the Fair Debt Collection Practices Act. It's a federal law that prohibits false, deceptive, or misleading practices in connection with the collection of a debt by a debt collector. Now, to be a debt collector under the FDCPA, the servicer must have taken over servicing rights after the default. So as a result, there haven't been a lot of cases brought under the FDCPA, but I think, you know, if you're in the practice area, you know that a lot of mortgages are in default and all the big banks are getting out of the servicing industry. So these cases brought in 2010, 2009, you know, they're still dealing with Wells Fargo and Bank of America, but as we start to see cases against Green Tree or SPS or a bunch of others, you know, I think it'll be much more common that mortgage servicers will be debt collectors under the FDCPA. So if you're looking for helpful cases, I suggest that you look under California's Rosenthal Fair Debt Collection Practices Act. The Rosenthal FDCPA is a state statute that's identical to the FDCPA, but it does not have the original creditor limitation. So that means that even if it's the original servicer, the Rosenthal Fair Debt Collection Practices Act applies. So you can look for cases that were brought under this related to HAMP and get an idea for what the analysis would be for a federal claim. The FDCPA claims that I've seen asserted tend to rise and fall with the contract claim, but I think there's room for an FDCPA claim where a contract claim fails. The standard under the FDCPA is the least sophisticated debtor, and I think if the servicer provides a TPP and it turns out it's not enforceable because the statute of frauds prevents it from being enforced, then I think you still have that the TPP is a communication that is misleading to the least sophisticated debtor who thinks they have a deal with their servicer, and the FDCPA applies. So there's some discussion of it in Corvello. There's also some discussion of it in the consolidated Bank of America HAMP contract litigation, which I believe I cite in the next slide. So this is on the state UDAP here in New York. We have GBL 349, and these are a series of state statutes that prohibit unfair, deceptive, and unlawful commercial acts and practices. Under most UDAPs, systematic breaking of consumer contracts is an unfair practice. So you might be able to get it just on the unfairness of giving a TPP and breaking a TPP. If you have an FDCPA claim, then you can also bring in the UDAP based on the unlawfulness of the underlying because the actions break the FDCPA. These also tend to rise and fall with contract claims, but are theoretically broader. As I said, I think, even if the TPP is technically unenforceable, you might be able to convince a court that issuing these and breaking them is unfair, even if there's not a binding contract. The Wygod case has a great discussion of Illinois' UDAP, and the Bank of America consolidated HAMP contract litigation from the District of Massachusetts discusses a total of 9 state statutes. So you can really see what the analysis is and how it's generally pretty similar from jurisdiction to jurisdiction. Next, I'm going to talk about ECOA. The Equal Credit Opportunities Act requires a creditor to respond to applications for credit, including an application to change the terms of an existing arrangement within 30 days. And the creditor must supply a notification if it takes an adverse action. There is an exception for borrowers who are in default. So this claim can definitely only apply to borrowers who have applied while in imminent risk of default. And even then, courts have tended to find, although not always, that a denial of a modification is not an adverse action under ECOA. And in the Bank of America HAMP litigation, the court said that, these people who have TPPs and then they just don't convert, that non-conversion is not an adverse action. But there have been other district court cases that have found this to be an ECOA violation. One more issue that I actually didn't make a slide for, but that I think merits about 30 seconds of comment, is fraud. A lot of cases include a fraud cause of action. I think it's generally pretty easy to plead. But I think the problem is that you'll never be able to prove the intent of the person at the servicer who issued the TPP, and that this person knew that they were misrepresenting, that the TPP would be converted. But that's going to be, I think, just so extremely fact-specific as far as what you can prove about their intent that we don't really need to talk about it in a general HAMP webinar. So if there are no questions about the nationwide stuff, I will turn it over to Jay, since we're at the halfway mark.
Joseph, before you turn it over, actually, there is one question.
Okay.
Question regarding what about a Fair Housing Act claim? Is there any possibility for a Fair Housing Act claim?
If you've got the data and you can show that there is, and you want to bring a disparate impact claim, I'm guessing is the idea. But like I said, I think the issue is just, do you have the tons and tons of data that's required there? Or I suppose if there was some discriminatory intent, but again, the issue would be finding enough information to actually prove that would be very difficult. Okay, so on that note, I'll send it over to Jay.
Okay, hi. Hopefully everyone can see my screen. I'll assume I'll be hearing some screams if you can't. I'm going to talk about how these issues have played out in New York as best I can. Kevin overstated things when he said at the beginning that I'm some kind of expert on HAMP litigation. I'm really not. The only reason I'm doing this training is because I don't do a very good job of saying no to Becky when she asks me to do training. I'm also the reason why this got extended to an hour and a half, because when we first mapped this out, my idea was to make Joseph do all the work, and suggested that he spend about 40 minutes on the national side of things, and I said I would just spend 20 minutes figuring there really wasn't much to talk about in New York. But then when I started preparing for it, I realized there was actually a bit more than 20 minutes worth. So you can blame me for the fact that this is going to be an hour and a half. I apologize for that. I'm going to be talking about two major prongs about HAMP litigation under HAMP in New York.
Jay?
Claims.
Jay,
yes.
I'm sorry to interrupt you. Can you hide your control panel? Hit the little orange arrow.
Oh, sorry. Sorry about that.
And then go to the top and do from current slide.
Sorry about that.
That's okay.
Is that better?
Yes, much better. Thank you.
Oh, I'm so sorry. Even though we did a tech run through, it obviously didn't sink in. So I'm going to talk about two different aspects of litigation under HAMP. Claims under HAMP itself, trying to enforce trial payment plans, but also permanent modifications, because although they haven't led to any adjudicated decisions, we've had a number of cases with permanent HAMP mods gone bad that have led to some litigation. So I'll get into some of that. And I'm also going to talk about violations of HAMP in the context of settlement conference advocacy, because that's an area where there has been a little more traction litigating under HAMP in New York than there has been actually directly under HAMP or under HAMP agreements. So this may be a little depressing, sort of hear what New York courts have done, and for that I apologize. I will try to walk us through the case law. It's going to necessarily be a little bit disjointed because as I went through the case law, I really struggled to find any kind of organizing principles around which to coherently organize things. So I'm going to just present it as I found it, and we'll take it from there. Before we even get into the main part of the discussion, I just wanted to point out that, in relatively early days, we had a decision sort of dealing with the intersection of HAMP and our foreclosure process in New York, and the Second Department actually reversed a trial court that had denied a motion to stay a foreclosure sale pending a HAMP modification application, and without really discussing it as in terms of whether, to what extent the state courts were bound or to what extent HAMP is enforceable, the court just simply said, these kind of dual tracking things should not be happening, and the court should have granted the stay for him to apply for a HAMP mod. So that was early on, but that was at least a favorable interaction with HAMP. So talking about other aspects of HAMP that have been addressed by the courts, I put on the screen a relatively recent case called Hart versus Ocwen, which found a failure to state breach of contract and the implied covenant of good faith and fair dealing claims that were based on mortgage or modification applications, not even really addressing a trial payment plan or anything like that. Those claims were rejected, but the court allowed to survive a promissory estoppel claim based on an instruction from Ocwen to stop making mortgage payments and a promise not to initiate foreclosure until a loan modification application was decided. It rejected negligent misrepresentation claims. It allowed our Deceptive Practices Act claims to survive a motion to dismiss. Again, this wasn't specifically a HAMP case, but it did at least suggest the kinds of claims that can arise under, arise out of HAMP applications. Just to touch on something that Joseph said about other states where you can have claims based on the Deceptive Practices Act, the State Deceptive Practices Act. It's just worth noting that in New York, we have a more limited Deceptive Practices Act. It covers only deceptive practices and not unfair. It would be really nice if we had unfair within our statute, but we don't. So that's just something to be aware of. Here's another relatively early case at the trial level, which was an effort to assert claims under HAMP more or less directly, and it was a co-op foreclosure case granting a motion to stay a sale pending service of the required UCC notices, where the bank's initial notice of sale was defective, but it denied a motion to compel determination on a HAMP loan mod application, citing various decisions holding that HAMP provides no private right of action and the absence of any authority authorizing the court to order a loan modification. Of course, this was a co-op case, so those are non-judicial foreclosure situations and are not governed by our settlement conference law. I think arguably there's a little bit more authority in a conventional foreclosure case where you have the settlement conference statute to argue that those standards actually do apply. Here's another case which was, again, relatively early on, seeking to enforce claims directly under the servicer's breach of the servicer participation agreements under HAMP. Here the court held that those violations did not supply the meritorious defense prong that's needed when you apply to vacate an order in a foreclosure action. It didn't offer any particular analysis other than to just say that the homeowner was not an intended beneficiary of the servicer participation agreement. That goes back to what Joseph talked about. It seems kind of crazy that people take the position, or courts have decided, that homeowners are not intended beneficiaries of HAMP, but that has become the accepted wisdom, and I use the term wisdom lightly. I wanted to mention affirmative claims under HAMP in New York with respect to permanent modifications. Several complaints have been brought in federal and state court and have asserted various claims: breach of contract claims, breach of the implied covenant of good faith and fair dealing, fraud, misrepresentation, promissory estoppel, equitable estoppel. We have sometimes set up claims under RESPA as a way to get yourself into federal court. If they start trying to enforce a permanent mod, if they start trying to collect on the original amounts due when you had a permanent mod, you can then file a notice of error and a request for information and set up a RESPA violation based on that. Joseph touched on Fair Debt Collection Practices Act. When you're talking about permanent mods, again, this could be efforts to collect based on the incorrect amount due. There could also be Fair Credit Reporting Act violations when things are reported to the credit reporting agencies. Deceptive Practices Act claims, and again, ECOA claims that Joseph mentioned, again, available if the homeowner was not in default when they applied for a modification. And again, with the caveat that if there's some question whether action on a loan modification is going to be treated as an action on a credit application. Okay. In general, when we're talking about contract claims, and Joseph touched on this nationally, but we have some New York-specific law that touches on this, is a loan modification supported by consideration. So we actually have in New York a statute, General Obligations Law, 51103, which specifically says that an agreement to modify a security interest in personal or real property is not invalid because of the absence of consideration, provided that the agreement, promise, or undertaking shall be in writing and signed by the party against whom it is sought to enforce the change, modification, or discharge. So that's helpful to the extent that you have a piece of paper signed by the lender or the lender's agent. That only goes so far, but that is at least something if you are in that fortunate situation of having a signed paper.
Hey, Jay.
Yes.
Jay, it's Becky.
Yes.
Hi. So there's a question. Can I just throw it out to you?
Sure.
I'm taking the place of Kevin, officially starting now.
Right.
So any luck filing private right of action under CFPB servicing regs?
Not to my knowledge. It's still kind of early days, so I'm not aware of cases, or I certainly haven't found any reported decisions. That's not to say that people haven't attempted it, but I haven't seen it yet.
Fair enough. Okay, thank you.
Sure. So on the breached permanent modification cases, we filed a few of them. None of them have reached the stage of getting decided. As far as I'm aware, they've mostly settled. We did include in the materials a couple of examples which sort of show how we pled these claims and how we've, both of these examples that I put up on the screen were set up as federal cases, and they assert the range of legal claims that can arise out of these. But I'm not aware of, I think if you have a signed permanent modification, there's much more likely to be a settlement because there is, a pretty unequivocal contract claim in that circumstance. So those have been settling. That's not to say that it has deterred lenders from trying to change their minds and back out of these deals and offer less favorable modifications instead, but these cases have been settling. So here let's get to the thornier problems and where things get more depressing in New York. Because the real question and the real problem is, of course, failure to convert TPPs into permanent modifications and all the associated abuses. So this is a fairly recent case that was extremely disheartening to many advocates in New York, Davis versus Citibank, affirming the dismissal of an action brought by the homeowner. Homeowner did not assert any kind of third-party beneficiary theories or any direct claims under HAMP. The claims that were asserted were for breach of contract, fraud, promissory estoppel, the Deceptive Practices Act. The court held that although those claims weren't barred by judicial estoppel because they had not been scheduled in a bankruptcy case that the homeowner had gone through, which was the reason why the trial court had dismissed the claims, they rejected outright all of the claims based on the idea that HAMP does not support third-party beneficiary claims, even though there were no third-party beneficiary claims. And the sole reasoning offered for throwing all of those claims out without any analysis at all were that they were, quote, intertwined with HAMP. This is really a pretty abysmal decision. I can't really sugarcoat that. It's a pretty depressing decision. What's interesting to me is that there's all kinds of other state law which is arguably intertwined with HAMP, and we'll sort of talk about that in the settlement conference context, and they haven't just refused to consider anything relating to HAMP in that context. So I don't really think this is defensible analysis, and unfortunately, it was a decision that shouldn't have been rendered because the parties to the case had actually settled the case and didn't show up for oral argument at the second department, and the second department then rendered its decision. So it's not, it wasn't even capable of being appealed because the case had actually settled. But I don't have anything good to say about this decision, needless to say. Other cases where New York courts have addressed failure to convert TPP claims. This one relied on the Myers decision, which many of you are familiar with in the settlement conference context, and I'll be talking about that one later. I'm sure you all remember Myers. It invoked Myers to hold that the trial payment plan is not a binding agreement. Myers precluded plaintiffs' claims for breach of contract, fraudulent negligent misrepresentation, fraudulent inducement, Deceptive Practices Act violations, quiet title, and breach of fiduciary duty, and held that the plaintiffs could not state cognizable damages from failure to convert a trial payment plan because accrual of interest under the mortgage is not recoverable damages. This was a situation where the plaintiff had brought this case after it was on the verge of getting relief in the context of settlement conferences in state court, and in order to avoid that, Wells Fargo just didn't appear for the hearing and discontinued the state case. And the court viewed this case as just an effort to do, to relitigate the good faith motion that it had made in state court because Wells Fargo successfully extricated itself from getting a ruling in that situation. My reaction to that is like, yeah, okay, why can't they do that? If Wells Fargo manipulated the process to avoid an adverse ruling and having some kind of relief entered against it in the state court case, why can't you bring an affirmative claim? But this court in Brooklyn saw otherwise. Another case, and I'm going to present this case both at the trial court level and then when it went on to the appellate division level, Seller versus City Mortgage. Each one of them is not helpful, and they're bad for different reasons. So at the trial court level in this case, the court dismissed the breach of contract claim based on a trial payment plan that was not signed by the defendant and where it contained hedging language, basically acknowledging that it was not a loan modification until all conditions were met. The court also held that the good faith and fair dealing claim failed for lack of an enforceable contract, and it rejected the promissory estoppel claim for lack of a clear and unambiguous promise, which I find hard to reconcile with the typical language that actually appears in most TPP agreements. Here, the court focused on the fact that the bank's obligations were conditioned on full execution of the document. The court did hold that the Deceptive Practices Act claim was not preempted by federal law to the extent based on misrepresentations. So at least it held out the possibility that you can have a Deceptive Practices Act claim. But here they held that the claim failed because there was the ostensible promise to withhold negative credit reporting information wasn't adequately alleged in the complaint or supported by any papers in opposition to the motion to dismiss. It's really hard to tell without having the whole record before you whether that decision made any sense. But in any event, what really governs is the treatment of the case by the first department of the appellate division. And here, what the court came up with is that allegations that the defendant told the plaintiffs that in order to qualify for a loan modification, they had to make themselves delinquent. They held that that had no broader impact on consumers at large for purposes of the Deceptive Practices Act claims. And the other thing that they said is, hey, there's no showing that telling them that they had to do that was false. And also no showing that the defendant actually reported credit delinquency contrary to the representation to the plaintiff that they wouldn't do that. Allegations of Deceptive Practices Act violations based on processing of the HAMP mod application were held to have been waived at oral argument. I don't quite understand that, but that's what they held. And then they gratuitously said, in any event, the Deceptive Practices Act claim based on alleged violations of HAMP rules and directives would constitute an impermissible end run around the absence of a private right of action under HAMP. So we now have, some pretty lousy rulings from both the first department and the second department, ostensibly, covering at least the New York City metropolitan area. So that's kind of a bummer. Some other claims. Here's one from Queens County, not offering a lot of analysis, but denying a motion to enforce the trial payment plan, to dismiss or to schedule a hearing for failure to negotiate in good faith under settlement conferences, basically simplistically relying on Myers and just reciting that the trial payment plan was not signed by plaintiff, and imposing the terms of the trial payment plan would violate plaintiff's due process and constitutional contract clause rights. Here's another one. Now here we're getting into the territory of some cases that have been brought in federal court. So here the Eastern District of New York concluded that there's no intended beneficiary theory under the service or participation agreement or contract claims based on failure to convert a TPP, which it viewed as merely a stage of the modification process and was therefore not an enforceable contract right. It also held that the promissory estoppel claim failed for lack of an injury based on an alleged reliance on a promise to modify, but at least afforded leave to replead. The other thing here was that the Deceptive Practices Act claim survived a motion to dismiss. Here the plaintiff adequately alleged consumer-oriented practice and a materially misleading practice by alleging that the defendant routinely asks homeowners to resubmit documents on pretextual grounds, misleads homeowners, violates TPP agreements, and delays decisions on permanent modifications. So it suggests that what sometimes determines whether those kinds of claims, Deceptive Practices Act claims, succeed is how well they're pled, and there can really be a big difference in sort of just including some boilerplate and really going to the trouble of alleging a pattern and practice that some judges at least want to see a little bit more of when confronting a Deceptive Practices Act. They don't want to see something that really just speaks to an individual transaction between individual parties. Here, the court denied the ECOA claims, holding that denial of a HAMP modification did not trigger ECOA's adverse action explanation requirement. But this at least gives you some glimmer of hope that some of these claims can survive in New York. Going to the other end of the extreme, here's a case decided by Judge Whalen in Suffolk County, and I have a hard time understanding how this came about unless the homeowner's attorney has lived in a cave for the last 6 years. I'm not sure what would make you think that if your case is assigned to Judge Whalen, it's a good idea to try to seek relief on these theories, but someone thought that that was a good thing to do. Judge Whalen denied an application for an order directing plaintiff to permanently modify a mortgage following the borrower's compliance with the trial payment plan and for interest tolling, noting that HAMP vests servicers with discretion over modifications, and the trial payment plan language stating that any permanent modification was subject to subsequent approval prevented any contract claims based on it. It also rejected relief premised on waiver and promissory and equitable estoppel, and declined relief based on principles of equity, bad faith, and unconscionability, holding that a determination not to modify a mortgage that's under no legal obligation to do so is not unconscionable conduct and does not constitute bad faith. I probably shouldn't have even wasted my breath going through this case with you, but it is out there. Judge Whalen did have the opportunity to weigh in on this subject. Yet another case from the Eastern District, which again at least leaves a little bit of a glimmer of hope out there. This Piscini case, it dismissed in part a complaint based on failure to convert, dismissing the third-party beneficiary contract claim back when people were still making those claims, and dismissing the unjust enrichment claim, but it upheld the contract claims, the promissory estoppel claims, and a negligent misrepresentation claim. And it upheld in part a fraud claim and allowed leave to replead. So we have some federal district court cases from 2012 that give you something on which to hang your hat if you're trying to litigate under TPPs, but we've got some pretty bad state court cases. I've included in the materials a sample TPP complaint that's pending right now in state court, which was filed before some of the bad state law came down, and there's a motion to dismiss pending right now, which it's not clear how the judge is going to deal with it, but that at least gives you an example of what a complaint looks like based just on state law claims. But I can't make any predictions on what the court is going to do with that. But I would say that if you have the ability to set these claims up for going into federal court, you might get a more hospitable reception there. So I think there's a lot to be said for sort of trying to set up a RESPA violation or some kind of federal claim to go into federal court. I just wanted to sort of also point out, although this is not necessarily HAMP-related, claims can ensue from modification scenarios. This is a recent complaint recently filed by one of our advocates, which triggers ECOA because the homeowner wasn't in default when she reached out to try to get loan modifications, and she was induced to apply for HAMP mods, given 2 trial payment plans when it turns out that she was never going to be qualified for a HAMP mod, and she was placed in default and foreclosure, and the servicer refused to consider her for non-HAMP alternatives. So it asserts a whole host of the typical claims you would expect to assert in that circumstance. So I should say, in the interest of full disclosure, there's also a motion to dismiss against that case pending. So you shouldn't commence one of these if you don't have the stomach to actually litigate them, because they will generally result in some kind of substantive motion practice. All right, so I'm going to turn to the less depressing part of the presentation, which is HAMP's interaction with our settlement conferences, because there things have played out a little bit differently. I'm pointing out just at the outset the relatively recent Sarmiento decision from the Second Department, which finds a failure to negotiate in good faith in some measure based on HAMP noncompliance. That was really part and parcel of the analysis. If you read through the opinion, it's really suffused with how the plaintiff violated all the various requirements of HAMP in acting or not acting on the defendant's loan modification applications. There's no actual discussion of whether HAMP the standard or one of the standards for measuring good faith negotiation. It's just sort of presumed in the context of settlement conferences, where what you're trying to do is broker a HAMP mod that HAMP applied to evaluate the plaintiff's conduct. So I think that's helpful in that regard. And of course, it also embraced a sort of a totality of the circumstances standard for measuring servicers or plaintiffs' good faith or lack of good faith, so that obviously that whole universe or totality of circumstances encompasses the governing regulations for the HAMP program. This was another Second Department case which reversed an order after a good faith hearing, which stayed the case and directed the plaintiff to reevaluate the defendant for a HAMP modification, and it remanded to the trial court with an instruction to determine whether there had been a failure to negotiate in good faith. It relied on the principle articulated in Myers that the settlement conference law can't force parties to agree, and accepted plaintiff's conclusory testimony that the defendant was HAMP ineligible. And it said that the court shouldn't have instructed the plaintiff to consider the defendant for a HAMP modification. So this is kind of hard to reconcile with the earlier case that I pointed out at the start, that Ames funding case, where the court held that the action should have been stayed pending a HAMP mod consideration. But I say this all the time. Second Department decisions are largely schizophrenic, and one can usually find a Second Department decision to support any point you really want to make. And here, of course, is the Myers case, which I alluded to earlier. I assume most of you are already familiar with it. It affirmed a finding that Wells Fargo failed to negotiate in good faith, but remanded because it was unhappy with the remedy that the trial court had imposed, which was basically compelling Wells Fargo to execute a loan modification based on the terms of a TPP, holding that the settlement conference law doesn't authorize imposing the terms of a settlement, and without a lot of analysis, treating the TPP as non-binding, without really going through the fact that the TPP actually had various obligations that the parties undertook to each other under it, and invoking the sanctity of contract and the contract clause of the Constitution, interestingly invoking that only with respect to the original mortgage contracts, but apparently the TPP contract is not really entitled to any kind of sanctity of contract. So this case, for better or for worse, and really for worse, does get cited ad nauseum, not just in the settlement conference context, but in all other contexts in New York, for the principle that TPP agreements are non-enforceable. And that's fine for them to cite it for that proposition, but there is actually nothing in that decision providing any analysis saying why that should be so. Most recent case we have on the subject of settlement conferences held that the record supported a referee finding of lack of good faith over the course of 10 settlement conferences, where the plaintiff's counsel represented that defendant might qualify for HAMP, repeatedly asked for submission of additional documentation for HAMP applications, and finally advised the court that it denied review of a HAMP application because of a PSA restriction, a pooling and servicing agreement restriction, or what we call an investor restriction, when it knew that restriction prevented HAMP modification all along. Again, there isn't any explicit discussion here about HAMP standards of technically governing, but again, it's just presumed that what we're talking about in the settlement conference context, at least, are efforts to negotiate HAMP modifications, and there's an implicit assumption that to that extent, at least, the HAMP is enforced in the settlement conference context. These are just a few examples of trial-level decisions which routinely rely on HAMP violations as indicia of failure to negotiate in good faith in the settlement conference process. There's really not much. There are lots. These are just examples. There are many more of these. The Rodriguez case that I have up on the screen is a decision from the Bronx. Actually, has some really good language. It says it's the most appropriate benchmark for good faith settlement negotiations, and it goes through an analysis about why that is so. So that's really helpful. If you're at least addressing HAMP in the context of settlement conference issues. Here's another case from Brooklyn, the Israelov case. And again, the court noted that the good faith obligation required plaintiff to seek a waiver of the investor restriction, which was asserted as a bar to a HAMP modification. This was kind of an idiotic fact pattern because, in fact, the plaintiff had gotten a waiver, but the letter it got waiving with respect to this particular defendant also said that they're not waiving it for other cases. So they actually idiotically argued to the court that they couldn't get a waiver when they had a letter in their hands that said they got a waiver, just not for other cases. And then here's another case from the Bronx with typical pattern of applications for HAMP where he was never properly evaluated for HAMP, and the court again very clearly held that all the very particular requirements of the HAMP program, the violation of all those particular requirements very clearly established a failure to negotiate in good faith. And there are a few more of these. These are, just so that I don't get accused of being myopic towards New York City. Judges around the state have reached similar conclusions. The Ross case from Ulster County, repeated failure to comply with HAMP requirements supported a finding of failure to negotiate in good faith, and Niagara County, a decision, again, similarly relying on HAMP requirements to find a failure to negotiate in good faith. And then here's one additional one from Brooklyn. The court specifically said failure to negotiate in good faith based on plaintiff's failure to adopt an adequate process to evaluate and act on HAMP applications, presuming that within the context of the settlement conferences, what we're trying to do is achieve HAMP modifications, and finding a willful disregard for the mandates of the federal program, the state statute, and the uniform rules of the court, sort of conflating all of them together. And one other example, here's a Queens case, failure to timely communicate any alleged deficiencies in submissions in connection with a HAMP application, or conversion of HAMP TPP into a permanent modification, inability to confirm receipt of documents, all supported a failure to negotiate in good faith finding. It's not really terribly controversial at the state level in the settlement conference context that HAMP is one of the main criteria to look to for establishing compliance with the settlement conference law requirements. And here are two more cases, one from Suffolk and one from Dutchess. Again, more or less saying the same thing, which I feel I don't really need to belabor. So just to sum up, I think I'm sort of within time here. Claims based on breach of permanent HAMP mods are viable sort of under basic contract law. I think if you can find a way to bootstrap federal claims and bring those in federal court, that's the way to go. TPP claims are somewhat questionable in New York, not completely a dead letter, but there's some real challenges We'll see what happens with a few of these where there are motions to dismiss pending. Again, if there's a way to get those into federal court, that is probably going to be a more hospitable environment. But in settlement conferences, and I dwell on the settlement conferences because I wanted to have something that wasn't too terribly depressing to talk about, at least in settlement conferences, it's not terribly controversial now that there are aspects of HAMP that the courts will enforce. So with that, I'm happy to open this up to any questions or comments or observations. That's all I got.
Thank you, Jay. So there's a number of questions that actually Joseph answered in the questions box. So hopefully if you ask the question, actually I think they all came from one person, but hopefully you see them. If you have any follow-up questions to those, please put them into the questions box. So we have two outstanding questions. The first one is the servicer the real party interest in the settlement conference if it invokes investor restrictions as the reason for denying modification?
I'm not sure if there's case law out there explicitly addressing that, but my view is I don't think it really matters. In other words, the servicer is the agent for the foreclosing party, and they are participating on their behalf in the settlement conference process. So, you know, it might be an issue if you're trying to frame an affirmative claim and you have to figure out who you want to go after. Then it's probably an issue whether you can go after the servicer or not. But my view is if you're talking about what's happening in the conferences, they're there in an agency capacity on behalf of the owner of the loan, and their behavior is chargeable, if you will, to the owner of the loan, and it shouldn't really matter. I don't know if others have a different view of that. But.
Yeah, Joseph? Oh, sorry, I was getting a little bit of feedback. Okay, so the other, I'm fine with that answer. So the other question is, it seems a little bit outside of the scope, but perhaps you can address it at least. I have a case, a non-HAMP mod, where the bank is revoking a modification. There was no trial payment period in this case. The bank issued the permanent modification documents, which the borrower executed and returned. After receipt of the modification documents by the bank, it appears they found judgment, thus revoking the modification. Is there anything that can be done to show bad faith on the bank's part and force them to honor the executed agreement? The client is not in foreclosure.
I wasn't clear from the way the question was posed whether the mod had been signed by the lender or the servicer. Is that?
My assumption, just understanding how these work, my assumption is that the homeowner never received a countersigned document.
Right.
And in fact, it seems that's when they tried to sign it. Perhaps that's when they discovered these other issues. But they're not in settlement conference. There's not this good faith standard at all.
Right. So that's the kind of fact pattern where we have brought affirmative cases. So there may be some challenges with the strict contract claim because you don't have a signed writing, but that wouldn't necessarily deter me from asserting the other somewhat squishier claims that are out there. I mean, yes, it's true that promissory estoppel may support only a limited limited amount of damages, but my view is most of these cases are, the client wants that modification back, and a painful litigation about the subject can sometimes make that happen or make a different but still good modification happen. So the fact that, if this were to actually get litigated to completion and that particular claim might not support a huge amount of damages wouldn't necessarily deter me, because what you're really trying to do is, get back that failed mod. So I hear that scenario, and even if the contract claim is a little sketchy, I say, yeah, that's a litigation. You should bring a case, you know.
Yeah, and I would add to that I would start out by sending a notice of error and say, my loan was modified, I got my permanent modification documents and sent them in, and now you're billing me on my pre-modification amount, so my accountant's in error. And then, you know, if you want to litigate the issue, you at least have the specter of an attorney's fees recovery, so that even if you only get a little bit of money for the damages, as Jay pointed out, you have a big messy litigation because they also have to pay for fees.
Yeah, and what Joseph suggested also is, you know, also setting you up for a federal claim if they don't properly respond to the notice of error. So you've got a RESPA claim. Sounds like you have a claim if they're doing some kind of effort to collect on the unmodified amount, and we take the position that that's not the right amount that's due. That's a violation of the Fair Debt Collection Practices Act. So I think we've just made this into a federal case for you. You know. Yeah,
and I think if there's one thing to learn from the litany of terrible state court cases that Jay went through, it's that you're probably better off in federal court on these cases.
Yeah. So I will, although this related, well, actually, this actually might be helpful. One of the samples we gave you was the Simpson complaint. And if my memory is correct, although that was a failed HAMP mod, it was based on a permanent mod that, you know, after quite a long period of time, the bank changed its mind. But I'm pretty sure we had that problem with an unsigned agreement there. So we have done this when we don't have a signed agreement.
And if these are counselors that are facing this, this would be a prime case to refer over to your legal partner.
Absolutely. Absolutely.
Definitely.
At this point, I don't see any additional questions. Okay, so here's another one. CPLR 3408 states that the person who appears at the settlement conference must be fully authorized to dispose of the case. If the investor is not there, is that person present? Is that person present at the settlement? If the investor is not there, is that person present at the settlement conference? Does this change your answer regarding above?
I think that's following up on what you had said, Jay, about the authority of the servicer to be at the settlement conference.
Yeah.
Yeah, look, that's a little murky, but, you know, our judiciary hasn't really shown itself to be terribly interested in enforcing the requirement of appearance with settlement authority at the settlement conferences. And attorneys are allowed to appear. They should be able to reach someone with decision-making authority. It's the norm that they don't have access to someone with decision-making authority. I'm not, you know, it doesn't necessarily need to, I don't think it necessarily needs to be the investor itself, because you can't really identify, you know, the investor is this amorphous pool, you know, participants in these mortgage securitizations, you know, so the investor operates through a servicer, and the servicer may have to go through a process where it gets authorization to do something, but I don't think you can really say that, you know, you have to show up in court, you know, with this amorphous concept of an investor in your back pocket.
Okay, I don't see any more questions. I don't know if Michelle, we probably didn't read it out loud, but there is the CLE code, which is in the chat box. It's M409P. And Michelle, do we have anything else that we need to announce?
Nope, that's it.
All right, great. So I don't see anything else. Jay and Joseph, thank you so much for your help in putting this together and presenting today. It was the half hour that I heard was fabulous, so thank you.
Thank you.
All
Thanks
right.
for listening.
Thanks, everybody. Have a good afternoon.